He's on Mulberry Street.
Oh, yeah, I was reading about that today. Well, I had shared something a couple of months ago.
Oh, yeah, that's the one. This is.
It's right next to in this building,
The New Point Grand apartment.
Because it is not going to move down one side. No, my brother is, and so I'm wondering if it was moved down to all sides. Thank you for everything. No.
Good afternoon, everyone. I would like to call this meeting of the Public Challenge Voter Hearing to order today, July 1st, 2024, 4 p.m. We would like to recognize any of our visitors. We're glad you came to see us. We do not have a public comment section The only people that we will hear from today are voters whose names are on the rolls that are being challenged. I will ask, as my constituents ask, there's no crosstalk, there's no outburst. If you do, you will be removed from the room. So today, we are here for an overview of challenged voters. Some that are supposedly have moved to North Carolina, some that are supposedly voting in other states, and some that are registered by P.O. boxes. So the purpose of this hearing is to determine the validity of these documents and determine what we can do if or what we should do based on the information we have. At this time, we go ahead and ask for the cases to be presented.
Thank you very much. Let me express my appreciation to the Board of Elections for another opportunity to present voter challenges, voter address challenges today. Thank you also for the feedback received at the last voter challenges. Your previous comments have informed the new challenges in my presentation. Just as we had to understand the poll watching rules through practice, so also we'll improve our voter challenge process through practice. I see voter challenges as poll watching of the voter roll. So what am I trying to accomplish with these challenges? My purpose is simply to help move us toward the cleanest voter roll possible, which lists only lawful voters. Every unlawful vote dilutes the vote of a lawful voter. My hope is that every voter on the list I submitted will list the legal permanent address in which they live and vote accordingly. My focus is on valid residential addresses in Bibb County. In no way am I accusing the voters involved of any intent to do wrong. The voter challenge allows us to get it right in Bibb County, and failure to follow the law and willful refusal to ignore the evidence and disregard the law could put our county in legal jeopardy. The Bibb County voter rolls are ultimately the responsibility of the Bibb County Board of Elections. The voters on the list represent a diverse group of demographical categories, including Republicans, Democrats, and unaffiliated voters. I appreciate the diligence of the Bibb County Board of Election employees' willingness to try to do what is right. And the voter roll problems appear to be systemic and may require legislative or judicial action, but as a voter in Bibb County, I feel responsible to try to correct the problems I see, and I would ask the Board of Elections to join me to make our voter rolls as clean as possible. In this challenge, I make no distinction between the active voter list and the inactive voter list. The distinction between inactive and active voter list is meaningless for this challenge because all a voter must do to move from inactive to active is request a ballot or show up to vote. If a voter is disqualified due to not having a valid residential address in Bibb County, the voter doesn't belong on either the active or inactive voter list. They are not inactive Bibb County voters because they are not a Bibb County voter at all. If any voter on the voter list provides a residential address in which they live in Bibb County, I ask my challenge to be withdrawn for that voter because I want them to be able to vote in the precinct where they live. Although the Georgia Secretary of State has responsibility for the voter roll statewide, this does not relieve the Bibb County Board of Elections from the legal responsibility of cleaning up our county voter rolls. If the Secretary of State's office was successful in cleaning up the voter rolls, I would not be bringing these problem registrations. So what do I mean by lawful voter? I'm only challenging the residency qualification in the Georgia Code, Title 21, Elections 21-2-216, which lists the following qualifications, among them a resident of this state and of the county or municipality in which he or she seeks to vote. So my challenges today apply to two different sets of voters. One, voters who have listed a post office or UPS center as their resident. Two, voters who have filed a USPS change of address form indicating their permanent residence is in another state, who have registered to vote in another state, and who have voted in another state. For these challenges, the qualifications for a voter under Georgia law apply, especially those that deal with residency. Georgia Code 21-217 lists rules for determining residence. The following laws apply to my challenge of residency. One rule is the residence of any person shall be held to be in that place in which such person's habitation is fixed, without any present intention of removing therefrom. 2, a person shall not be considered to have lost such person's residence who leaves such person's home and goes into another state or county municipality in this state for temporary purposes only with the intention of returning, unless such person shall register to vote or perform other acts indicating a desire to change such person's citizenship and residence. Rule 13 says if a person goes into another state and while there exercises the right of the vote of a citizen by voting, such person shall be considered to have lost such person's residence in this state. And 15, Rule 15, for voter registration purposes, the Board of Registrars and for candidacy residence purposes, the Secretary of State, election superintendent, or hearing officer may consider evidence of where the person receives significant mail, such as personal bills, and any other evidence that indicates where the person resides. Now, we're making a little history here, and that you're the first election board to hear a voter challenge under SB 189 that becomes effective today. Section 13.595B of that bill states that Section 5 becomes effective July 1, 2024. Section 5B states probable causes shall include but not be limited to an elector voting or registering to vote in a different jurisdiction, or an elector being registered at a non-residential address as confirmed or listed by or in a government office, database, website, or publicly available sources. If a challenged elector's name appears on the National Change of Address database as maintained by the United States Postal Service as having changed such elector's residence to a different jurisdiction, the presence of such elector's name on such database shall be insufficient cause to sustain the challenge against the elector unless additional evidence would indicate that the elector has lost his or her residency as determined pursuant to Code Section 21-2-217, which I referred to earlier. According to case law, county registrars may determine whether residence requirements are met. County registrars are free to take reasonable and adequate steps to see that all applicants for the right to register to vote fulfill the requirements of bona fide resident. McCoy versus McElroy, 1972, says, as the Supreme Court of the United States has emphasized, the defendant registrars are free to take reasonable and adequate steps, as have other states, to see that all applicants for the right to register to vote actually fulfill the requirements of bona fide. Registrars and Georgia have the power to require that voters be bona fide residents of their political subdivision. In accordance with OCGA 21-228A, the Board of Registrars of each county shall have the right and shall be charged with the duty of examining the qualifications of each elector of the county. Furthermore, in April 3, 2018, Georgia State Election Board hearing minutes, we can read this exchange between Judge Simpson and the Georgia Secretary of State's Chief Investigator, Russell Lewis. Judge Simpson said, I think it's very clear in the law that you have to have a physical address to vote. You can't use a post office box. Isn't that correct? Mr. Lewis, yes, sir, that is correct. Judge Simpson, in the past, we have had cases where election officials have allowed people to vote based on post office box, and you can't tell where they are living in a precinct for the candidate for whom they vote. I think we do not need to begin down a path which will allow additional fraud in the voting process. I think the law says we have to have a physical address. If we are going to have fair and equal elections, we have to follow the laws we have on the books. Additional, Chris Harvey, Georgia Secretary of State Elections Director, stated the voter registration system is designed so that addresses are recognized as either residential or commercial, and it is designed to prevent somebody from being registered at a commercial address. The Bibb County Board of Elections has a duty to determine whether voters meet the residency requirements under Georgia law and to protect the integrity of our elections from unlawful votes. I'm not questioning the intent of the voters who listed addresses in which no one lives or those who remain on the voter list, even though they have filed a document with the United States Postal Service indicating that they have moved their permanent resident to another state and have registered to vote in another state and who have voted in another state. I am challenging the qualification of these voters to remain on our list without showing in what residence and precinct they live in Bibb County, given that they have established no domicile in Georgia or have moved their domicile to another state as indicated by a change of address form and registering to vote in another state and voting in another state. How do we know what ballot to give them if we don't know where they live?
My desire is not to take away
Their vote, but to ensure that they vote or they are lawfully allowed to vote. So the first challenge is 45 USPS, UPS commercial addresses. And I'm challenging the invalid addresses of a list of 45 voters because they're registered to post offices, highlighted in blue, or UPS stores highlighted in brown, and cannot live at these places. Therefore, you cannot determine what precinct they live and who they're allowed to vote for. How did I find this information? I simply searched the Bibb County voter rolls for addresses of post offices and UPS stores and found the attached list of voters who were registered at those addresses. These voters are incorrectly registered at a commercial address and not the residence in which they live. They must be registered where they are a legal permanent resident. These voters should be disqualified until they provide a residential address as their permanent residence and domicile. And here is a list of the post office and UPS stores and their addresses for evidence, as well as your own voter roll that has these voters at that address, those addresses. Do we want to take one at a time or go ahead and do the other one? Okay. The second group are 47 voters who voted in North Carolina. I'm challenging the voter registrations of the attached list of 47 voters because they are residents in another state as indicated by their written USPS change of address form listing their new address in North Carolina and registered to vote and voted in North Carolina as shown by their North Carolina voter lookup. Under the law, you must remove voters who do not meet residency requirements. The attached Excel spreadsheet contains registration records documenting electors' moves from Bibb County to a North Carolina address where they have also registered and have voted. The spreadsheet's a convenient listing of information compiled from state and federal source data using Eagle AI Network and an app analysis tool. It's a shame that some people are more concerned about the tool used than they are about the problems with the voter rolls the tool uncovers. It's like blaming the inspector for problems with a product instead of dealing with the product problem itself. The tool compares the people who have filed a change of address form with the U.S. Post Office to voter addresses on the Bibb County voter roll. Then it compares the voter's full name and gender and birth year and the address listed on the change of address form with people who have registered to vote and voted in elections in other states. An elector registered in a state has filed and personally signed an NCOA form attesting that they are making a permanent move from the first registration address to a different registered address. Secretary of State's voter rolls are sent to the USPS official licensee to determine the USPS unique barcode. The USPS has assigned a unique barcode to every address in the U.S. The NCOA moving to address barcode is compared to the move to and registered barcode. Individuals registered at the moving to address are compared to the names of the persons at the move from address: first name, middle name, last name, suffix, name, date of birth, gender. If there's a match, the voter roll from each SOS voter roll is placed on a single line in the CSV file. If the elector has voted at the moving from or moved to address, the last election voted is also included in a single line in the CSV file. The written sources accessed are the change of address form, the Bibb County voter roll, and the voter roll from another state. Now, this process is not simply comparing Joe Brown of Macon to Joe Brown of Charlotte. Instead, it's like matching Mr. Joseph Brandon Brown, age 51, who filed a change of address form saying he was moving from 301 Cherry Street, Macon, Georgia, to 501 Main Street, Charlotte, North Carolina, with Mr. Joseph Brandon Brown, age 51, who is registered to vote at 501 Main Street, Charlotte, North Carolina, and has voted in that precinct. The chance of a mismatch is next to zero. Furthermore, to prove the information on the spreadsheet was accurate, I have printed out the voter records from North Carolina on each voter and submit them as evidence. Every line is accurate, as backed up by the voter record. And so here are 45 voter lookups from North Carolina, showing that these voters have registered and voted in North Carolina. Challengers are only required to present a preponderance of evidence that a registered has changed their legal residence. They do not have to look them up on a Secretary of State website, but I've done that with these North Carolina voters. Nor does a person have to vote to be eliminated from the Bibb County voter roll. A permanent change of address is enough, and voter registration in the other state is more than enough. I've gone beyond the requirements to prove these voters should not be on the Bibb County voter roll. They will not breathe a sigh of relief as they can vote, as one reporter stated after the last challenge. They probably don't even know they're still on our voter roll and have no intention of voting in Bibb County. However, leaving them on the voter roll opens the possibility that someone else could fraudulently use their voter registration to vote. It also causes us to resource voter that should not be voting in Bibb County. We'll have more than what we say we have. We'll have to resource for them. And of course, we want to follow the law. These voters have given us evidence of an out-of-state residence and should be disqualified from voting in Bibb County unless they move back and establish a residence here again. The National Voter Registration Act of 1993 says that unless the registrant confirms in writing the registrant has changed residence to a place outside the registrar's jurisdiction in which the registrant is registered, that is the written documentation needed. So the documentation is a change of address form, voter registration history, and voting on a ballot is indicated by the voter record. The last group of challenges are those registered to vote and voting in other states, of course, not Georgia or North Carolina. 151 of those. As an elector in Bibb County, I'm challenging the voter registration of the attached list of 151 voters because their residence in another state indicated by the written USPS change of address form listing their new address in another state and registered to vote and voted in another state. The same AI tool that accurately identified North Carolina voters has identified these voters with their change of address, new voter registration date, and date of voting in another state. The Bibb County Board of Elections can confirm this information is correct with information you have that I don't have. Under the law, you must remove voters who do not meet the residency requirements, and you should, especially if they voted in another state. If you still doubt the information on the spreadsheet, why not make removal of these registrations contingent on checking their voter record in another state? And for further evidence that the spreadsheet is accurate, I have printed out 60 North of Florida registration records, 60 of them. Here's the application to vote in Florida. Here's the app in Florida, and on it, you are required to be a resident of Florida to be able to vote in Florida. And here are their voter registration records here, in which they have wrote. Now, their voter information doesn't list whether they voted or not, but they have registered in another state and indicated a residence in another state in Florida. And I was able to get those from the Florida voting roll. County registers must determine whether residence requirements are met. County registrars are free to take reasonable and adequate steps to see that all applicants for the right to register to vote fulfill the requirements of bona fide residency. McCoy versus McElroy, as it read prior to the 1994 repeal and so case law there. in accordance with OCGA 21-2-228, the Board of Registers of each county shall have the right and shall be charged with the duty of examining the qualifications of each elector of the county. So it's your duty to do this. So finally, I thank you for the opportunity to present these challenges, clear up the voter roll. I'm just asking the Board of Elections to follow the law. The voters are diverse regarding party and other demographics, but all need to establish a residential address in Bibb County. To leave them on the voter roll invites unlawful votes and disputed elections. Thank you.
Thank you. Do you have any of the voters here who are challenged on that roll?
Probably not.
No, it's the mayor.
Excuse me?
No, it's the mayor.
Oh, God. We never filed, okay. What now?
Whether they got them.
Well, they only, based upon the address we had and all that.
Went to deliberation, Madam Chair.
Yes, you have to just go now with deliberation.
Madam Chair, if I might, I have a few questions for the challenger. Just to make sure we have this, what's your name for the record?
David Summerall.
Thank you for that. And just to confirm, are you a registered voter in Bibb County?
I am.
And what is your residential address, just to confirm your residency in the county?
I'm registered 405 North Bay Drive, Lysell, Georgia.
Okay.
052.
Thank you very much for that. I see that in your cover emails, you signed your challenge as David Summerall, Chairman, Bibb County Republican Party. So you're bringing this on behalf of the Bibb County Republican Party, is that correct?
Just one of my titles, I have many titles, so that just happened to be the one that, the email that is populated.
Okay, so you're not bringing it on behalf of the party?
Yeah, it really doesn't matter, I'm elected in the.
Okay. Have you ever met or spoken to any of the voters who you're challenging today?
The only one that I know, I haven't spoken to her recently, is, it used to be Ashley Lincoln, I think it's Ashley Lincoln Langley now in, North Carolina. Because I used to coach each with her. Did not know she had married, did not know she had moved to North Carolina, but saw her name on the list. And the face, you could tell on Facebook that she had moved to North Carolina, was there with her husband.
Okay. So other than her, you don't have personal firsthand knowledge
I
regarding
don't,
any of
and
those
I haven't
voters?
spoken to her in
Okay.
years.
All right. You claim the voters you challenged have moved, but you haven't asked any of these voters whether they've moved temporarily and plan to move, return to Bibb, is that correct?
It doesn't matter.
I'm asking, is yes or no?
It doesn't matter. I haven't, because all they have to do is register to vote.
Okay, and since you don't know these voters personally, is it also correct that you don't know whether any of these voters are college students, members of the military, moved to engage in government service, or are U.S. citizens living abroad?
It doesn't matter. If they've registered to vote in another state, they can't vote in Georgia.
All right, I've got some questions for Mr. Nolan as well. First of all, are we just in general as a board required to comply with federal law?
Yes.
Okay. And more specifically, are we required to comply with the National Voter Registration Act?
We are.
Okay. I looked up NVRA with this hearing, and isn't it correct that NVRA 20507 paragraph D1 says the state shall not remove the name of the registrant from the official list on the ground that the registrant has changed its residence unless the registrant, and then there's two conditions listed here. One, confirms in writing that the registrant has changed residence, or two, or B, has failed to respond to a notice described in paragraph 2, and has not voted or appeared to vote in an election during the period on the date it's noticed and ending on the day before or day after the day of the second general election for federal office that occurs after the date of notice.
That is correctly read.
Okay. So under NVRA, if we suspect the voter may have moved, our only legal course of action under this statute is to send them written confirmation and wait 2 federal election cycles unless the voter confirms in writing that they have changed their residence.
Can I ask you a question? Does that have any comment about whether they voted in another state or not?
It does not say anything about that.
I look at this section, the answer, generally is yes. I look at this section, as, because it talks about change, there is a distinction between a change in address and an original registration of somebody, and we talked about that at the last challenge, hearing, or at least leading up to it. But yes, I mean, it certainly says that, and Georgia has passed laws that would seem to be at odds with this particular.
Right, I'm just trying to make sure that we're doing the right thing here. So again, under NDRA, if we suspect a voter may have moved, the process is to send written confirmation, wait 2 election cycles, unless the voter confirms in writing that they changed their residence.
For a change of address, yes.
Yeah. All but 2 of the voters on the North Carolina list are inactive, and all but 1 on the other state list are also shown as inactive. So if we go to section 235B.
Say it again one more time, if you don't mind.
Sure. All but 2 voters on the North Carolina list are inactive, and all but 1 voter on the other state list are shown as inactive. Section 235B of the Georgia Election Code says, and I'm quoting here, an elector placed on the inactive list of electors shall remain on such list, shall, until the day after the 2nd November general election held after the elector is placed on the inactive list of electors. Now, am I reading that correctly?
Again, does it say anything about them voting in another state?
So
It is silent on that.
let me ask Mr. Gill your question. So if I lived in Bibb County and I go to register in North Carolina, would there not be any type of notice sent or anything?
For good world, yes. In our world, I don't know that.
Stop.
Have you looked?
I have evidence that didn't happen.
Wait,
It's not.
There's supposed to be a multi-state clearinghouse to do that. I don't know that it's working,
Stop.
working very effectively.
Madam Chair, could I continue here? So, based on my reading of the Georgia Election Code, we can't remove inactive voters from the voting list until 2 federal elections have intervened. Is that correct?
To the extent that the intent of that is that you can look at it one of 2 ways. One is the intent of that section is to make sure they're not placed back inactive, or that they're not removed from inactive at all. I think what you're saying is consistent with federal law as well, so I think it's wrong.
Now, federal law and state law.
Correct interpretation. 235 and the voter registration act appear to be consistent with each other.
And the challenger alleges that these voters have registered to vote in another state, but has not provided us with a copy of voter registrations with their signature. And again, going back to NDRA 20507 D1, one of the requirements there is a confirmation in writing that the registrant has changed address. Surely a signature on the voter registration form would constitute that confirmation in writing, and sometimes that would be received from other states. So that is the mechanism.
Would not confirmation be that they voted in another state, they had to register in another state?
What I'm seeing under section 232B, again, of the Georgia Code, is that we can't remove the voters unless we receive a copy of the voter registration application with their signature. Now, if there's an allegation that somebody is living in another state and is improperly voting where they no longer live, then I think that would be a matter for referral to another authority. But we're just talking about today how we maintain these lists. So again, 432B, and I'm quoting here, when an elector of this state moves to another state and registers to vote, and the election or the registration officials in such state send a notice of cancellation, reflecting the registration of the elector in another state, which includes a copy of such voter's voter registration application bearing the elector's signature, the Secretary of State or the Board of Registrars, as the case may be, shall remove such elector's name from the list of electors. It shall not be necessary to send a confirmation notice to the elector in such circumstances. This is something that we don't have in front of us today. Going on, paragraph 2, when an elector of this state moves to another state and registration officials in such other state or other non-governmental entity as described in subsection D of Code Section 21-2-225 says notice of cancellation or other information indicating the voter has moved to such a state, but such notice or information does not include a copy of such elector's voter registration application in such other state bearing the elector's signature. The Secretary of State or the Board of Registrars, as the case may be, shall send a confirmation notice to the elector as provided in Code Section 21-2-234. So I think the recourse here is to send notice, but we don't have signature that's required under Georgia law and state law. And I've got a couple more questions for the challenger regarding PO boxes. So the voter that you said you did have personal knowledge of, that was not one who's on the PO box challenge list. Is that correct?
That's right. What?
The voter who is, who you said you have personal knowledge of.
This weekend,
Yes, right. She's not one of the ones listing the PO box. She's not on that
No,
list.
she's not.
Okay, okay. So you don't know where these voters later head tonight, do you?
No, I just know they don't live in a post office or UPS.
For all you know, these voters could live in the county today. Is that correct?
They just don't live where they're voting and they're registered.
Are you aware that under Georgia law, voters who are victims of violence or harassment can participate in the Georgia Vote Safe program and use a mailing address as a registered voter address in the public voter file?
And they could use it like a domestic place or a DFAX or somebody. They can't use a post office or a UPS store.
I think you're misreading the law in that program there. The Secretary of State's office is pretty clear. And isn't it correct that you don't know whether any of these voters are keeping their home addresses confidential because of fears of violence or abuse?
No, they just don't live there.
All right.
Madam Chair, I'd like to leave 3 paragraphs in reference to these particular, this is the state law that's just came out effective today, SB 189. Line 102 says if a person, this is a direct quote, a person registers to vote in another state, county, municipality, or legislative district for any type or sort, that person shall be deemed to have changed his or her residency. Line 105, if a person returns to his or her original or new residence after voting or registering to vote in a different or separate jurisdiction, such a person shall update their voter registration with their current registry jurisdiction in order to be deemed a valid register elector and the resident of such jurisdiction for voting purposes. Line 109, proof of ownership or residential or rental or post office box, private mail box, service addresses with a particular jurisdiction shall not constitute sufficient grounds to establish a person's residency within that particular jurisdiction. End quote. And that's Georgia law as of today. I can't read it any place. It's their law, not mine.
Madam Chair, if I might, federal law has not changed though. National Voter Registration Law, National Voter Registration Act is still,
It's a state
right, and the National Voter Registration Act is federal law. Just to be clear, Mr. Nolan, nullification is not something that we do currently. Is that correct?
I'm sorry, say vote no?
No, nullification with regard to state law superseding federal law.
No, the federal law takes precedent over state law, where they're inconsistent.
Right, and the federal law states very clearly, a state shall not remove the name of a registrant from the official list on the ground that the registrant has changed address, unless one of 2 conditions has been met. That has not changed, even though we do have a new state law. The federal law is still there and says, if the person confirms in writing that they've changed address, remove their name from the rolls. If they fail to respond to a notice and have not voted or appeared to vote in an election during the period on the date of the notice and ending on the day after the date of the second general election for federal office that occurred after the date of the notice. We don't have any evidence that any of these voters on the two challenges based on change of address have met those conditions.
Yes, I do think I would make one, generally speaking, yes, I absolutely, I agree. I think one distinction, and this may not even speak to what you're saying, Mr. Jonathan, one distinction I would make is that challenges under 21-2-230 don't result in a striking of the voter from the rolls, right? So, and that may be a distinction with the national voter registry. If we were talking about striking them from the rolls, absolutely. I think
That's not what it's called.
yeah, but follow that. There's a process here now. But I also would agree that just and this is in the law, this is Georgia law too, just the change of address data from the USPS doesn't do anything. But the addition of the registering to vote and perhaps also voting would. But I think that the operation of 229, I don't think we're even talking about at this point, but 230, I do.
Just so
think-
everyone's clear on that,
Right.
can you just go through the
Sure, so
operation?
there are two ways, there are two challenges, and it's easy to conflate the two, and I think we've all done it at times, but there are two, there's 21-2-229 and 21-2-230. 229 is challenging a registration that would then be stricken. Under OCJ 21-2-230, and this was part of the new law, although it existed before, but it's been, subsection B has been rewritten. And this part was in the original. Upon the filing of such challenge, the Board of Registrars shall immediately consider the challenge and determine whether probable cause exists to sustain such challenge. If the registrars do not find probable cause, the challenge shall be denied. Simple enough. If the registrars find probable cause, the registrar shall notify the poll officers of the challenged elector's precinct. Or if the challenged elector voted by absentee ballot, notify the poll officers at the absentee ballot precinct, and if practical, notify the challenged elector and afford such elector the opportunity to answer. And then there are a lot, I won't read the whole statute, I'll spare everyone now, but there are, as you go forward in the language, a lot of different scenarios where somebody shows up to vote and they're on this list and the challenge has been sustained, what you do under those circumstances. So I do think.
So, if I understand that correctly, probable cause is found on under 230, then those voters can be placed on essentially a challenge status.
That's what I call it, but I don't think that's necessarily used, but that's what I would.
Right, so that was my question. I read the law. It calls for this board to just come and determine whether there's probable cause. It doesn't tell us that we're gonna remove anybody from the polls. Cause probable cause means that we notify the voter. Am I not mistaken?
There's a procedure.
No, there's a procedure where we notify the voter to tell us whether or not, why you were at a post office and why we shouldn't take you off the roll. Am I correct with that?
The vote today is not to remove them, the vote today is to sustain the challenge and let the process work.
Right, and that process could be, we end up coming back and finding out that the federal law won't allow us to do that.
I do think that's why the process exists in national voter. You know, I mean, these are two different tracks, but
I just don't
I think that's why there is a
understand why
process
state
where it
would pass
doesn't
laws
just happen immediately.
I just don't understand why state would pass laws that completely usurp federal government.
I mean, there's precedent for that.
It is a good point, Mr. Captain. It is a good point as to why they have certain.
I understand, I just don't understand the process and that logic, but I do understand that taking somebody off the voter roll is very serious.
And I don't want to overstep my bounds, so if anybody's questions, I'll answer them. If any legal questions.
So
Address.
the only thing we do today is to determine whether it's probable cause, and I'm going to vote on each one of these separately as well, I think. to move it forward to what?
Okay, so there are three options, right? You could vote that probable cause is not been met, that's one option. So the second option would be to sustain the challenge and put them in status. And there's a third option, which would be to table the issue of whether to sustain or reject the challenge and ask the staff to look into these issues further. And that is not listed.
What's the difference between 2 and 3?
I think the official placing into the status and looking at, if you go through 230, I know y'all have all this. So if you put someone in this, what I think Member Ellington described as challenge status, which I think is accurate. If the challenge elector appears at the polling place to vote, such elector shall be given the opportunity to appear before the registrar to answer the grounds of the challenge. The challenge elector does not cast an absentee ballot, and does not appear at the polling place to vote if the challenge is based on grounds other than qualifications of the elector to remain on the list of electors. No further action by the registrar shall be required. And because this is really talking about a specific election, right? And that's what we're talking about is November, as to whether they be allowed to vote in November. If the challenge elector does not cast an absentee ballot, does not appear at the polling place to vote, and is based on other than the elector is not qualified, the board of registrars shall proceed to hear the challenge under 229. Back to 229. So there's more. There are all these different steps that you take once someone's in that status. It would be whether you wanted to deliberate about whether to put them in that status for the November election. I am, absolutely.
Just to be clear, the new law, SB 189, says that the evidence that's been presented today does satisfy the burden of proof.
Probable causes shall include but not be limited to an elector who is deceased, an elector voting or registering to vote in a different jurisdiction, an elector obtaining a homestead exemption in a different jurisdiction, or an elector being registered at a non-residential address as confirmed or listed by or in a government office, database, website, or publicly available sources derived solely from such governmental sources. If a challenge elector's name appears on, and then it goes through the same national change of address database, is not good enough.
But looking at the voter registration and voting in another state is.
But
This is certainly what the law, what the law is. Yes.
we're still down to name for name and birthday for birthday. We
Well,
still have.
Madam Chair, it's not birthday for birthday, it's birth year.
Birth year, okay, excuse me. So, again, you know, how do we validate this? How do you validate this information?
Again, we're not taking them off the list today. We're gonna let the process work.
Well, I guess the way the process would work is whichever we vote on, then the staff has to get into it, verify and contact the individual voters, if I'm not mistaken.
I think you'll end up doing that either way, but I think you'll end up doing that either way, but if you sustain the challenge, there really isn't, I would think you would still do the research, but there isn't research required. They place in status and you deal with it if they show up to vote, right? That's the thing. If you table it and set another meeting to make the decision, and ask the staff to research in between, that's, you know.
And again, when does early voting start? October.
Right, you do press up on where you can't sustain voter residency challenges, at least under 229 or 230, because you're not removing them. I think that's the distinction.
Madam Chair, this isn't a legal note, I'm cognizant of the fact that there were 2 occasions in the last 10, 11 years where using national change of address forms could, in this manner, could have personally disenfranchised me. And I don't think that either the Georgia General Assembly or Congress intended that. Fortunately, the first time I was in Korea on the Fulbright grant. Very fortunate to be able to do that. And at the time that I left for Korea, I was going to be gone for 9 months. And I gave up my apartment here because there's no point in paying rent on a place I wasn't going to live in. The sole address that the Board of Elections had for me was P.O. Box over on College Street. And yeah, I had a friend pick up mail there for me from time to time because it was not feasible to get bills sent to me in Korea. But I did not intend to permanently vacate Bibb County or Georgia. I had every intention of returning. I voted by absentee ballot while I was overseas, and I am grateful that my right to do that was protected by UOCAV. So that's one thing. On another occasion, in 2019, I filed an NCOA form and had my mail sent to Cambridge, Massachusetts, where I was going to be at the Kennedy School for more than a year. And NCOA forms can't go out more than that for forwarding. So I had to file another change of address form when I came back here. But again, my intention on going up there was temporary in order to improve my education. I voted by absentee from Cambridge, and I returned here. And we don't know whether others are similarly situated. Disenfranchising a voter is serious business, and we have a process in place for dealing with list maintenance. The Secretary of State's office actually does a solid job. I think it's striking that on 2 of these lists, all but 3 of the voters are listed as inactive. They are following the process that is envisioned under the National Voter Registration Act. And I think that we are better off letting the professionals follow their process than dealing with guesswork. And that's, in my estimation, what this is. Thank you.
No. I think we need to, if it's okay, you take these one by one, it's up to you. Listen, the first one I want to address is the post office box, and I've done work with these guys, I've done a lot of folks in town, and just the majority of these people are in active status. And I think it's important to verify where they live so they can get the proper ballot. And I think it can be done very discreetly. I think it can be done by simple letter, asking them where they live. And so I would move that we sustain the vote on the post office box list, please, for our, to put over, there is calls on the post office box list for our staff to look into, to verify these people are residents, and maybe it could be a driver's license issue, but I'd like for that list to be looked into.
And Madam Chair, just to be clear, if this motion goes forward, is this to remove these voters from the roll?
No,
or
absolutely
replace
not.
them in challenge
I
status?
think that's important. Thank you.
Not.
Ms. Jones. And I think that's important for us to decide that at this point, these are being considered for probable cause.
Correct.
Under OCGA 21-2-2 code and not use restriction.
Correct. We are not bringing them to the vote. I mean, the box. This is just.
I'll second that motion.
Call for a vote. Those are in favor of sustaining the post office list. Aye. Those not in favor, aye.
Aye.
Aye. So the post office boxes will be sustained and the office will
And so those are in challenge status.
challenge that, right? And the office will make contact with those people Carolina.
Are these two similar in their scope? I mean, they're all from other states and North Carolina.
Well, one is, I think this is Florida, some other states other than North Carolina.
Basically the same thing, or all these out states.
You have one that is strictly North Carolina, because I could show that they.
Yellow.
North Carolina. The other I went through because I could look it up. The Florida border roll does have the birth dates on there, so you can look it up.
My question was, are they so similar that we could use, consider them together? Because it's the same thing, just in different states.
No different information.
Different, okay, we don't have to keep them separated.
And I would say these two are slight, well, not from each other, they're slightly different from PO box lists, and that was relying on outside evidence to send our voter registration.
Right.
That's, it's still up to the board, not me.
Madam Chair, I would just emphasize that we don't have any test of the veracity of the evidence of that beyond what we have internally. And if it's in order, I would move that we dismiss the North Carolina challenges.
Second.
All right, the North Carolina list to be dismissed, all in favor, say aye.
Aye.
All opposed? Same sign. North Carolina list will be dismissed.
All right.
And
And
the other state lists.
Madam Chair, for the remaining list, I would move that be dismissed as well.
Just for the record, information was given to us, it was presented properly, it is valid under Georgia law. I think we're doing a disservice to the voters in this county. Looking into this and making sure that these people are registered, or should not be registered yet.
There's 3 people on the list that are active. Just 3 out of all of these 2 lists, 3 people are active. And so therefore,
Madam Chair, I'd be happy to hear the remainder of what Mr. Hazard said.
Point being, we're not following under law. Simple as that.
any other discussion? If the matter of the other states is on the table, all in favor of dismissing, sign say aye. Aye. All opposed, same sign,
Aye.
and this one has been dismissed also.
Second.
Thank you.
We adjourn, Madam Chair.
We are adjourned.